We have our first panel up. What are the current super torts and how are they affecting civil justice? PFAS, public nuisance, and more. Really, we didn't want to list all the different possibilities there, so just picked out a couple things, and I'm sure that we will have a much more extensive list from our wonderful panelists. And here to shepherd us through the first panel of the morning, we have Justice Bill Montgomery of the Arizona Supreme Court. So, Justice Montgomery, the floor is yours.
Thank you, Donald. Appreciate the invitation to be a moderator here today and to continue the tradition from yesterday. Introductions of our panel members will be very brief, but I really encourage you to check out their bios that are linked through the agenda. There's a wealth of experience here, and if you're looking at that while they're talking, that may help generate questions that will tap into their experience too. First, down to your left, my right, Mr. Zach Arbitman, who is a partner with Feldman Shepard and has extensive experience in helping plaintiffs recover over $250 million in whistleblower class action and catastrophic personal injury cases, joining us here today from Philadelphia. Next, we have Mr. Marc Behrens, who was introduced yesterday morning. Yes, he is double dipping on the panels. We really appreciate Marc being here with us, and just to note it again, he is a partner with Shook and Hardy and co-chairs their Washington, D.C. based public policy practice group, hailing from now Naples, Florida. Next, we have Jennifer Scullion, who is a New Jersey girl at heart, but also in Philadelphia now. She is a partner at Seeger Weiss, who has extensive experience across a wide range of torts and multi-district litigation, taking a leadership role in many of them, such as real quick, multi-plan health insurance providers litigation, the Apple smartphone antitrust litigation, in-race social media, adolescent addiction, personal injury products liability litigation. I could go on, but you will ask her about that when we open the floor to questions. And then last but certainly not least, we have Mark Williams, who is a partner with Nelson Mullins. He is an office managing partner in West Virginia and a team leader, and has extensive experience handling complex cases nationally in a vast variety of litigation areas, and has had first chair responsibility for more than 100 jury trials and appeals in his career. And so with this great experience, we are now going to share with you what's going on with super torts in the country. And to start off, we'll go with Zach.
Thanks, Justice Montgomery, and thanks to Donald for both the invitation and for putting together this great conference. It's great to see so many people interested in these issues in both the civil justice space and with respect to some of the hot topics of the day. And it's great to be here with such a diverse slate of panelists and conference attendees, and kind of really show that people can get into the same room together and have a lot of differences, but maybe iron some of them out, or at least respect one another's differences and reasons for having same. So thanks for everybody for joining. And as Justice Montgomery said, I'm a plaintiff's lawyer based out of Philadelphia. Have a ton of experience, both in the whistleblower realm, consumer class actions, environmental class actions, and then catastrophic personal injury and product liability claims. So I bring that perspective in my current practice, but also a perspective growing up as a defense lawyer, defending class actions at a large national firm. So I try to look at things, as I hope a lot of other folks do here, on both sides of the V, and inform my opinion with folks that know a lot more about about the defense side of things nowadays, but try to advocate for our interests as well. So one of the areas that I think I'm probably going to fall under the and more bucket of the super torts category that we're talking about with respect to, we have other folks that will address the PFAS, that will address public nuisance. I will be addressing and talking about what I term product defect or safety defect. Class action litigation is a pretty hot topic in the class action world now. And I'll be addressing it primarily through the lens of what the defense bar has called, or has tried to relabel, no injury or no benefit class actions. So we'll be talking about it through that lens. But before we get into kind of trying to dismantle some of the oppositional arguments, just a little bit background for folks that I know a lot of generalists are in the audience. So product defect class actions, product safety class actions are also known as economic loss class actions. They just so happen to come under the guise of the subject matter oftentimes is product defects or safety defects or material omissions, things of that nature. Economic loss class actions can also come under the guise of mislabeling. That oftentimes comes within, within the context of supplements and things like that. Economic loss class actions can also come within the context of environmental contamination. It can come into the context of data breach, as one of the Marcs will be discussing later on in a little bit more detail. But my particular focus, my background, and my firm's background is we deal a lot with product safety issues, right? We deal with them as a firm both on the injury front, right, with the single plaintiff catastrophic cases that deal with folks who have been harmed or maimed by dangerous products. But we're also dealing with them on the economic loss front, folks that have bought expensive automobiles, folks that have bought expensive kitchen appliances, folks that have bought parents that have bought dangerous children's, whether it's children's products, whether it's products to, as every parent knows, I'm a parent of 2 young kids, 5 and 2, so every parent is looking for the next product to get their child to sleep as quickly as possible. It just so happens that sometimes serious risk of harm and defects are not disclosed at the point of sale. And where that becomes important as part of kind of a right to advance in response to that is the idea that all consumers have informed choice, right? So if there is a material defect or a safety defect that a product manufacturer is aware of and they continue to sell the product, in order for the consumer to have the benefit of the bargain or informed choice, they should be aware of that bargain at or before the point of purchase. Whether that disclosure is made through advertisements that pervade the company's materials through websites or brochures or things of that nature, whether, ideally it would be on the packaging or the labeling or on the front center of the product. When people go in to buy it at, Walmart or Home Depot, things of that nature. But either way, there should be an opportunity for the consumer to make an informed decision about the money that they're spending and that the product they are receiving, right? That is a bedrock jurisprudential concept in American legal history, is the benefit of the bargain. I think it's relatively uncontroversial, but I think my colleagues here will tell me it is fairly controversial. But oftentimes, in the way it is generally cast in these types of class actions is as the benefit of the bargain, or if you are buying a product with a defect that you didn't know existed under the theory of overpayment, if you are buying a product that is a premium product, right? Oftentimes within the baby product setting, you are paying that premium for hoping that your child eventually goes to sleep, which oftentimes does not work. But either way, you're paying a price premium for something that you did not know either doesn't work or does not work as advertised or comes with safety risks that you were not aware of at the point of sale. From there, there's also a tangent of economic theory and kind of sort of more conceptualized as damages that views these issues through the lens of a diminution in value. Oftentimes that comes within the automotive products context, where there's a resale market for the product you purchased. You purchase, say, a brand new vehicle, drives off the lot 2 years later. There's a recall, going to one of the core functionalities of the vehicle or one of the main components that makes the vehicle dangerous to drive. I think basic economics will show supply and demand and basic common sense will show that vehicle is going to be inherently worth less at resale on the secondary market. So that's another way, yet another way, to conceptualize a consumer's damages within the context of economic loss in either a product defect or product safety class action. So, in terms of just kind of putting a little bit of meat on the bone, some of the examples that we've been talking about, cars sold with defects that, might lead to crashes. I mean, people are aware of probably the Takata airbag litigation. There was significant economic loss damages over that, right? Folks who purchased automobiles not knowing that their airbags would explode, right? I would think within the realm of common sense, those products that people paid tens of thousands of dollars for are not the products that they paid for and that they were hurt economically. This also extends to household appliances that have safety defects that folks are unaware of at the point of sale, whether it's microwaves, whether it's other products and the like, that either present the risk of injury. They might very well present the risk of fire. They could also very well, if you're talking about in the context of defective washer machines, risk of flood. I don't think that any reasonable consumer, which is the important standard and test when you're advancing statutory claims under the various UDAP statutes, would be buying something or paying the amount that they did had they known that these defects and material omissions existed. So those are generally where the areas where you see them often. And then, one of the questions to briefly address is, what are the causes of action that these damages theories are rooted in? Typically, the class action claims you'll see a standard bevy of common law claims. You'll see negligence. You'll see implied warranty claims. You'll see express warranty claims. You'll sometimes see breach of contract claims. You'll see fraud claims, fraudulent omission. And then you'll also see UDAP was a term I used earlier, kind of term of art. They're just basically state consumer protection statutory claims. UDAP is Unfair, Deceptive, and Abusive Trade Practices Act claims. Most, if not all, states have some form of state UDAP statute on the books, and they are oftentimes a common mechanism for advancing these types of economic loss claims. So I think what I've gone through now, generally speaking, probably, in terms of common sense, is largely uncontroversial. I think the benefit of one's bargain is, like I said, a bedrock principle in American law, right? However, the defense bar and other folks have done a good job of making these topics controversial. And that's come through really good advocacy. It's come from creative defenses. It's come from unique approaches to dealing with these types of cases. The way that, at least as I understand, some folks are attempting or have reframed these economic loss class actions is they reframe them as quote unquote no injury or no benefit class actions. And that's one of the issues that they take with them. And the second issue that they take with them are they reframe them as piggybacking class actions. The no injury, no benefit class action, obviously, I think is fairly easily dismantled by kind of the background that we laid already about the economic loss and the benefit of the bargain and things like that. I think the attack on the overpayment rule has been largely rejected by appellate courts throughout the country. And then the piggybacking piece of it, that generally comes within the context of a criticism of these product defect class actions tagging along federal government agency or corporate recalls. Now, the important pieces of that, well, one, I guess it's important to notice, I don't think I'd ever hear, and I've never thought I would hear the defense bar suggesting that something that the federal government doing is superior than getting something adjudicated through the class action mechanism. But even putting that aside, I think the important piece to recognize is sometimes those agencies are understaffed, sometimes the recalls are inadequate and that they don't cover the full slate of damages available to folks, both from an economic perspective or the availability of punitive damages and statutory damages. And sometimes they just don't quite reach the extent that they could be adjudicated through private litigation. I recognize that my sign is up, so I don't want to go for too much longer because we have quite a bit to cover. But I recognize that there's a lot to discuss in the panel today, and hopefully we can loop back and weave in some of these issues as we go.
Okay, thank you, Zach, and we'll go now to Mr. Marc Behrens.
All right, good morning, everybody. It's good to see you all again. So in my time today, I can maybe respond more when we get into my time. I want to very quickly, this is going to be like a highlights reel here in about 5 minutes. So in terms of what are the super torts of today and then what are we looking at for tomorrow, I think the super tort of today, you have some that are individual product liability cases. Talc, both mesothelioma and the ovarian cancer. There seems to be more of a split on the meso cases. On ovarian cancer, the defendant, J&J, is winning 96% or so of those cases. So I think it's focused more on the mesothelioma now. It was an attempted bankruptcy to deal with the ovarian cancer cases that fell apart a couple of times. We'll have to see where that goes, but talc is an area that continues to be of interest to the plaintiffs' bar. Some of these things I'm telling you what you know because you watch TV, right? You watch TV, you're going to see all these ads. The other is the Roundup litigation. Again, very mixed bag when these cases go to trial. Bayer, which is acquired legacy Monsanto, has won about half, maybe 60% of the trials. When they lose, though, the damages are extraordinary. And so this continues to move on. I think there were somewhere around 100,000 cases. They've settled many of those, but I think the latest report I saw is that there's still 30,000 or so cases left. And because it's a product that, like talc is ubiquitous, is still on the market because every regulator in the world says it doesn't cause cancer, we'll continue to see these cases come in. Camp Lejeune cases, the statute of limitations may have closed on that. I'm not aware. Do you know? I think the statute of limitations is probably closed on that. But that is litigation against the United States government for contaminated water exposures at Marine Corps Base Camp Lejeune, where the predictions of what it was going to cost and how many people would file lichen asbestos were very quickly swamped, and that litigation will go on probably for years. Yet the cause of action that continues to occupy public attention is public nuisance. Or I should say the twisting of the traditional tort of public nuisance into an area that we believe on the defense side it was never intended to be used for. So public nuisance is a tort that was to deal with an injury to a public right, like if there was pollution in a river and suddenly nobody in the public can use that river. But it's been transformed into what is an injury to a public right into injury to a lot of individuals suddenly makes it public, which we believe is not the case. In individuals, injury to thousands of people that may have been prescribed opioids is not a public right. But this is a tort that started with tobacco in the late 1990s, and we've seen efforts to push this proliferate into the opioids, where it resulted in a gargantuan settlement. We're seeing it now in against tech companies for social media addiction involving teens. ExxonMobil is facing claims in California over plastics recycling, where plastic, you may or may not know, when you take your plastic out to recycle, a lot of it's not recyclable. Dishes with food on it and things like that don't end up being recycled. They end up being burned or up in landfills. And so people are, the state of California is suing them for making recyclable products that aren't in fact recycled because of how consumers use them. And climate change continues to be efforts to move this. So this is a tort that, again, people have seized on to remove it for its traditional moorings, to try to make it the cure-all for perceived social ills, which it was never intended to do. And we're starting to see some pushback on that. By and large, the climate change cases have not been successful. Opioids was, in terms of a settlement. This year, the Ohio Supreme Court said, it's interesting because Cleveland was the home of the prescription opioid litigation, but the Ohio Supreme Court this year looked at the Ohio Product Liability Act and said that when you're really claiming harm from a product, that's a product liability action. It's not a public nuisance action that's actionable in Ohio law. Some states are responding. Montana this year codified its traditional law of private and public nuisance and made it clear that injury from a product, your typical product liability claim, is not a public nuisance. So we're seeing some pushback both from courts and state legislatures, but we'll continue to see this tort go forward. And then asbestos. You know, it's funny, I started representing a group in the year 2000 that files, it's not a tort reform group, but files amicus briefs in asbestos cases. And in the year 2000, the asbestos environment was marked by about 100,000 lawsuits being filed every year, and 90% of those people had nothing wrong with them. And it was causing a bankruptcy wave that knocked out the whole so-called asbestos industry. And so we were dealing with a crisis at that time, but it's amazing that I still file amicus briefs for this group 25 years later because the litigation continues to evolve. And what we see is as the so-called big dusties, the companies that made up the asbestos industry have gone through bankruptcy and become immune, the litigation has spread out. And now there are over 12,000 different companies that have been pulled into this litigation. Remarkably, after 50 years, there are still 100 companies named annually that are new to this litigation. New companies continue to be brought in. And in terms of cost spending by self-insureds or insureds, it still ranks up there with these other super torts as the dominant tort of today. It's funny because I still remember this 20 years ago, the general counsel for a major insurer, her CEO said, "What is the next asbestos?" And she said, "Asbestos." For 25 years, the next asbestos has always been asbestos. It just keeps chugging along. It still costs probably $3 billion a year. And the projections are that it's going to continue until the year 2050. So we're starting to see the litigation not only move from a handful of small, large defendants that made amphibole insulation, which is a very potent type of fiber that causes cancer, to more peripheral companies that are hardware stores, plumbing supply stores, auto parts suppliers, and things like that, as litigation's moved out. And the injuries continue to be mesothelioma, but we're seeing more and more cases that instead of being occupationally exposed workers, because many of those have aged out or unfortunately passed away from cancer because of massive exposures they had on ships in World War II or Korea, for example, that we're seeing more and more cases brought by people in their home, many of them spouses, because in that era, these were predominantly men working in the steel industry and shipping industry, and they would bring asbestos home on their clothing. And so we're seeing claims now involving family members, women that may have washed their clothes or children that played with them in the household. So that continues to be a dominant mass tort. And in terms of future, I'll mention PFAS. We can talk more about that. There are, I think something, and Marc is the expert, so I'll defer, 10,000 or so different PFAS-related substances. There's only a handful that have been proven or associated with cancer risk, but there are some studies that say maybe that there's some associations with various types of kidney cancer, prostate, and so forth. And if the science evolves to the point that there is a signature like mesothelioma is with asbestos, it will swamp asbestos. It's much more ubiquitous, more products, more people exposed, everybody's exposed. And so this is one where the science is not there now. We don't know if it'll ever get there, but if it does, it will be the dominant mass tort probably in our history. And then the other I'll mention quickly is the food litigation. So as a result of, or maybe in conjunction with RFK Jr. and the MAHA movement, look, RFK came from a plaintiff's law firm. He's a plaintiff's lawyer, and he's working with the plaintiff's bar. That's why you see the attack on Tylenol, even though a federal court just a few months ago said threw out on a Rule 702 motion, plaintiff's experts saying there is no link between autism and Tylenol. But RFK's pushing it, and he's pushing ultra-processed foods. And wow, isn't that a coincidence that while he's out there on the bully pulpit pushing this and issuing reports, there was a lawsuit filed in Philadelphia alleging that a young man who's severely obese got this way because he's addicted to ultra-processed foods. Now, this was tried in the early 2000s. You may remember the movie Super Size Me, about the guy that went to McDonald's every day and, claimed that he gained all this weight. Well, this was tried 25 years ago. This is the thing about torts. A bad idea never goes away. It just sort of, it's like shingles. It goes away and then comes back 30 years later. But it went away then. The focus then was against McDonald's and Burger King and saying, they all addicted us to fast food, and it's, somehow we're powerless to avoid going into Ronald McDonald because of the characters. But now the focus has moved away from the restaurants to the food makers, Kraft Heinz and companies like that. The first case was thrown out because the guy did a complaint that's about this big that literally reads like the story of the complaints against the tobacco industry 30 years but almost no history in terms of his own exposures, what products, what companies, when, how much. And so the court threw out the initial complaint saying you tell an interesting story, but there's no facts here about what this guy actually ate, when, or how much. And now a amended complaint has been filed. So we'll see where that goes. And then, so those are the future torts that we're looking at.
Okay, thank you, Mark. Next, Jennifer.
Hi, good morning, and thanks again for being here. Again, I'm at Seeger Weiss in New Jersey. My heart is in Philadelphia.
Oh, did I get that backwards?
It's okay. That's all right.
I know that's a serious sin on the East Coast.
That's okay. Actually, I have a background in commercial litigation for about 20 years, but I've been with Seeger Weiss for about the past 10 years, where my focus is on public nuisance claims as well as antitrust and consumer fraud claims. And look, I think what we're talking about here, while we're talking about super torts, mass torts, et cetera, is we're trying to grapple with, right, how do you address aggregate harms? One course of conduct that's causing widespread physical or economic injury. And one of the things that's, I think, is fantastic about our legal system is it evolves to meet the harms, right? It tries to say, okay, there's been a harm, how can we find, a remedy and make sure that the costs from the harm are not simply being externalized, I think is the word, from a corporation or a manufacturer, and having the public just absorb it.
They like that word at the
Yeah,
Law and Economics Center.
But externalized means, and I'm going to focus today on public nuisance. Externalized means that we all pay for it as taxpayers in the form of addressing public health, public safety, or other aspects of the impact of the nuisance. So I want to focus on public nuisance. This is one of the ways, I think, that we're trying to grapple with how do you deal with these mass harms. As Marc said, public nuisance goes back hundreds of years. As an article, it's in your reading. And basically, public nuisance asks, has something been done that harms what I would call the common, the public right, the commons out there? Could be blocking a public road, building a pigsty in the middle of a town. My favorites is operating a baudy house. Love that one. Just love the word.
Is that a bad thing?
No, but it's a great word.
Yeah. Can you
But
not do
also,
that?
to the point of, how broad is public nuisance, it also is applied to the selling of certain products, fireworks, adulterated food or drink. So it's not as if it was never applied to the sale of products. Since the late 1970s, and the Restatement Second of Torts has explained that public nuisance is an unreasonable interference with a right common to the general public. And typically what we're seeing is the right common to the general public are rights like public health, which is different in kind, not just magnitude, from individual health. I go to the doctor if I have an individual problem, but when we faced a public health epidemic, danger in COVID, it was a public issue. We all had to have vaccination or other protocols to try to deal with the public health issues. So it's different in kind. Public safety is also a public right that's been invoked in public nuisance. Public nuisance claims can be brought in parens patriae by government officials, but there's also private or quasi-private litigation either by individuals or local government entities, including school districts, that have suffered a special injury as a result of the nuisance. So there's a general injury to the public right, but some will suffer a special injury, usually because of the way that they need to redress the impact of a public nuisance. I did want to talk about two of the most recent examples I think that Marc touched on. One is the opioids litigation. So there, in addition to dozens of actions by state attorneys general, there were thousands of cities and towns and counties who sued manufacturers, distributors, dispensers of prescription opioids, and now the pharmacy benefit managers. And the allegations are that not that the product was defective. It's not that the prescription opioid pills were defective. If anything, they worked too well, right? They did exactly what everyone knew that they would do. The allegations were that the defendants pushed a huge increase in opioid prescribing by lying to doctors, regulators, and the public about both the benefits and the huge risks of using opioids, especially for chronic pain, that is, using opioids continuously over time. And one of the themes that was coming out in the marketing was, well, you can't get addicted if you're using the opioids for pain, which is just absolutely scientifically incorrect and was known to be incorrect. The other major allegation was that the defendants were making and distributing huge and grossly excessive volumes of pills and ignoring all the red flags that showed that they were supplying pill mills. So, for example, evidence came out in one of the trials that there were just cartons and cartons of opioids literally stacked up outside of the locked cage to be used for controlled substances, because these are controlled substances, supposed to be controlled essentially cradle to grave, from the time they're manufactured till the time that they are dispensed to a patient. The volumes that were being shipped were literally overwhelming all systems that were supposed to be in place to keep them under control. And it was known and continued to happen. So for the opioids litigation, there was an MDL in Cleveland, Ohio, in front of Judge Dan Polster, and a number of parallel cases around the country. As Marc mentioned, there were billions of dollars in settlements. There also were a number of trials. And again, this is where I push back on this idea that, it's public nuisance is going to be a tort run amok. No, it goes through the system the way any other tort goes through the system. Do we survive a motion to dismiss? Do we survive summary judgment? What happens at trial? And the trials were split. In some cases, we had a jury find, yes, we find that there has been a public nuisance here and damages. Other times it's been rejected. As Marc mentioned, some states have product liability regimes that have been found to preempt the public nuisance claims. So it's not as if it's out there, in the words of, I think it was the Third Circuit, swallowing all of tort law. It's taking its proper place to address, again, the actual public harms, which are different in nature and kind as well as scope from the individual harms. We also have the social media litigation. Again, you have attorneys general that are suing, but you also have school districts and local governments who are suing, saying not only were the individual children harmed, or in case of families of dead children suffered the loss of their child, but local governments and schools have suffered by having to respond to the harms of social media, principally. Huge increase in mental health and behavioral health issues for children, depression, anxiety, eating disorders, as well as in a number of localities, huge increases in fights, violence, because we all are not in this generation to know, but the idea is that the social media companies are incentivizing kids to post things on social media in order to get the likes, get the eyeballs on there. And one of the things that gets posted are fights. So people promote fights, and people get there just to video it and post it. Schools have to deal with that. Schools are dealing with the ubiquity of social media in the classroom, of kids being distracted, even during exams. You get the phone away. You can't trying to log in through your laptop or whatever. They will find a way. So the school districts and local governments are suing for the costs they've had to bear to deal with this, whether it's buying pouches to put the phones in at school, hiring more mental health professionals, or for a lot of schools that don't have those kind of budgets, they've had to divert their resources. So it's administrators, mental health professionals, teachers. How much time and energy are they diverting from actually teaching kids to policing them on social media, or dealing with the fights, or dealing with the breakdowns, dealing with kids who don't even want to come to school because they are feeling so anxious and bullied by what's happening to them on social media. So procedurally there, we have an MDL in Oakland in front of Judge Gonzalez-Rogers, and a parallel coordinate proceeding in front of Judge Kuehl in the California Superior Court. And the first trials in front of Judge Kuehl are starting this fall. So again, I think the common theme here is that for public nuisance, we're talking about something that's much more than a collection of individual harms. The sum is really greater than the part. So for opioids, it's not just about individual addiction cases. It's about the fact that a whole marketplace was created and fueled by the defendant's conduct. Same thing with social media. It's not just the individual children and their families that are harmed and that are suing in their own right. We're talking about the impact on our public sources, including our classrooms. What is happening? It's not just affecting that child that's having a bad experience on social media, but all the other children who are now losing resources that are being committed to having to deal with the social media disruptions. So it's different in kind, and I think public nuisance plays an important role in our system in addressing that different in kind harm, along with our traditional torts of negligence, product liability, fraud, et cetera.
All right, thank you, Jennifer. And now we get to Mark Williams.
Good morning, everybody. Thank you for coming. We really appreciate what you do for all of us in terms of adjudicating matters in our courts. And it's a critical opportunity that we have to talk to you about something that we feel is very important. And you're going to see, frankly, in the cases that you deal with. I'm going to talk about a little different type of mass tort. It's probably the fastest growing area of litigation in the country, and that's data breach and privacy litigation. It doesn't get the attention of PFAS or asbestos or Roundup, those sorts of things, but it is much broader in terms of its application. For instance, we know virtually everybody in this room has been the subject of a data breach at some point. You've probably gotten notification from a credit card company or an entity that you do business with that some aspect of your information has been the subject of a breach and that they have offered you some sort of identity theft protection and warned you to keep an eye on your personal information, right? It has become an epidemic that breaches are occurring at a much faster level now than at any time in our history. For instance, we know that data breaches have tripled in the United States since COVID. And that's not because entities are being more negligent in managing your data. It's because the threat actors, largely offshore in Russia, Eastern Europe, and China, have committed immense resources to pinging secure sites in the United States, trying to see if they can get in. I mean, we're in Washington, D.C., or outside of Washington, D.C., where we know from a national security standpoint that most of the entities of the federal government are the subject of attacks, cyber attacks, on a daily basis. Those are for national security reasons, trying to gain a tactical advantage in national security. What the threat actors in a lot of these foreign countries are doing is they're trying to get access into a system, obtain data, and then turn around and hold it ransom and try to get paid for it. And it usually occurs in one of two ways. They infiltrate a system through repeated efforts to try to find a weakness, and then they either lock down that system and send a notice to the company that says, you don't have access to your system now, and if you want access to your system, you have to pay ransomware, usually through Bitcoin, of several, either tens or hundreds of millions of dollars. Or they will infiltrate a system, take that information, post it on the dark web, and then say, we have your data, and we're going to sell it to the highest bidder on the dark web unless you pay this ransom. So what happens in that situation? Well, unfortunately, we know that almost every entity in the United States, whether it's a large company or a small company or a public entity, is subject to these kind of attacks. PACER, the system that handles for the federal judiciary case filings and provides access to those filings online, was the subject of a breach just last month. So now the federal government and the federal judicial system is looking to try to figure out a way to try to lock down PACER so that they can prevent access in that situation as well. When a breach occurs, entities have to go in and try to either pay the ransom, find out the extent of the breach, notify the individuals who were impacted by the breach, and when those notifications, which are required by law, occur, what happens? Litigation results. There are lawyers that monitor state and federal regulatory websites where when a breach occurs and you have to, an entity would have to provide notification that they have started the process of ameliorating the breach and they have notified individuals of the impact of the breach. At that point, those law firms will be looking for a plaintiff that they can find to file suit, and they want to file suit as quickly as possible. The problem is that the race to the courthouse that occurs for these class actions, and they're enormous. I mean, we're not talking about tens of thousands. We're talking about millions of affected individuals. When you race to the courthouse in order to be the first to file, hoping that then you have a better chance of being designated as class counsel, that creates a feeding frenzy in some respects. In 2024, Change Healthcare, which is a large health insurer, had a breach that occurred because of a malware attack, a ransomware attack. They paid $22 million in ransom and still did not prevent the information from being distributed on the dark web. The most recent indications from Change Healthcare, which handles a lot of our health information, indicates that it impacted 197 million patients, more than 1 out of every 2 Americans. And United Health Group, the parent of Change Healthcare, has publicly stated that they estimate that the cost to them in this year is $3.1 billion. That case is now the subject of an MDL in Minnesota. It's enormous and getting bigger every day, and it consists of 2 different types. One's the impacted patients who had their information taken by a criminal actor, and then providers who were not able to process claims and incurred costs as a result of Change Healthcare, who was responsible for managing a lot of the payments associated with our healthcare system. They weren't able to do that. So you have those 2 different sort of parallel tracks that are going forward in that MDL. So what do we do in a situation like that? Well, Change Healthcare, frankly, is facing, I don't know that they have enough insurance to even deal with this risk. And insurance is another issue that we'll talk about in a moment. But basically, when these sorts of cases commence, the problem is that a very small number of individuals actually have any injury as a result of this. Those of you that have received notifications that your data has been the subject of a breach, probably look and say, well, there doesn't seem to be anything that's happened to me. So you might have some sort of protection through some sort of insurance provision that would cover you for this. But by and large, the vast majority of people aren't going to have an injury. I think we can all agree that if someone is the subject of identity theft, they have credit cards taken out in their names, their identity is stolen in some respect, those people have legitimate claims and as a result should be entitled to some sort of compensation. But what about everybody else whose information may have been the subject of a breach, but nothing has actually happened yet? That's where the litigation is driving. In the federal courts, it's an Article III standing question. Most states have a similar provision that requires some sort of actual injury in order to be able to adjudicate that tort. So early in this litigation, when these cases are first filed, one of the first things that lawyers do, like me, is we challenge the question of Article III standing. The problem is the United States Supreme Court has not really given us clear guidance on that. There have been a lot of Article III standing cases that have come out of the Supreme Court over the last 10 years. None of them are specific to data breaches, but they do give an indication that some sort of concreteness and imminent harm is necessary. But there's just enough gray area in how they've described it that it's unclear. As a result of which, the federal circuits are split as to whether or not is it the risk of someone doing something with your data, is that sufficient to constitute a concrete injury? Or do you actually have to have some evidence that someone has taken some affirmative action with your information? That's really the rub. And I've litigated this issue in a lot of different places. Some circuits, like the 11th Circuit, has great law for defendants on that issue. You really have to have some sort of concrete, actual, ascertainable injury in order to proceed with Article III standing. But there are other circuits that say just the risk of it is sufficient to constitute a concrete injury. I think the Supreme Court's going to have to resolve that at some point. We thought that they had a case this last term where they were going to decide it. Turns out after oral argument, it was not the appropriate case, and they actually dismissed the appeal as improvidently granted. So we continue to wait for some guidance on that. But what we know in the meantime is that as we take these cases and litigate them, the take rate for class actions, which is the percentage of individuals who are given an opportunity to participate in a class action and actually choose to do so, the take rate traditionally in class actions is really low. I think the largest I ever had in a class action was about 80%. That was unique because of the judge really driving notice and giving people an opportunity to participate. But it's not uncommon in class actions generally for the take rate, that participation percentage, to be 15, 20, 30% or less. In data breach class actions, the take rate is inevitably single digits. Single digits, often less than 5%. Because most people don't think that it's worth it because all you're getting in compensation in terms of that class action settlement would be additional years of identity theft protection, maybe a fund that could be used if you have any out-of-pocket loss, which is usually not the case at all. So there's very little benefit for you after you get that sheet that describes the class action to actually say, okay, I'm going to go through the process of participating. But ultimately, when that resolution takes place, the parties that end up making the most money are the lawyers. And I'm not being critical of my friends on the plaintiff's bar because it goes both ways. Defense lawyers, between the defense lawyers and the plaintiff's lawyers, they're the ones that make most of the money on these cases. It's not the impacted individuals. So until we get some sort of guidance on how we're going to deal with these cases where an entity is being accused of failing to prevent a criminal act from taking place, and that's a liability question that's totally different than what we're talking about today. But until we get some guidance on whether or not an individual who has not actually been injured hasn't had anything actually done with their data as to whether or not they have an injury, until we get that answer resolved, I think we're just going to continue to see the process going and more cases being filed.
Okay, thank you very much, Mark. Now, everybody's had an opportunity to present some opening remarks. Are there any points or further developed points anybody would like to address or make? Don't jump in.
Let me ask my friends who are the plaintiff's lawyers, Jennifer and Zach, about this. My assumption on public nuisance and on the lack of the benefit of the bargain claims is that it was easier to prove. For instance, Jennifer, you said that in the opioid case, the claim was not that the opioid was defective, but that public nuisance was created. In my conversations with the plaintiff's lawyers, they told me that they thought that it was easier to prove that claim than it was to prove that the product was defective. And therefore, it was a more direct line to a favorable result to utilize public nuisance or some of these other claims. Not that that's a bad thing necessarily. It's something that the lawyers have to do every day, is make a decision tactically and strategically. What's the easiest way to get the resolution that you want?
So, I mean, I know, because I was involved in the initial review for opioids, and we were heavily involved in opioids. It wasn't about what was the easiest way. It was what is going to be effective here. And we knew that the theory in opioids was not that they were defective. They worked exactly like everyone thought they were going to work, exactly like the FDA, had approved. The problem was getting them out and distributing them and dispensing them to folks who didn't need it and who weren't properly warned of the risks, not telling the doctors of the actual risk of addiction, telling doctors these were newer generation, safer opioids. So our assessment was this was the appropriate, tort to bring. By contrast, in social media, both theories are going forward. There are the product liability theories, because we do claim that social media is in fact defective in the way that it has been designed, that its design is unreasonably unsafe for a known audience, and that is children, because of the way that it works on their brains. It's the same the same folks who designed slot machines gave the blueprints for how to design social media. And the science is really, proving this up. And the internal documents are indicating that everyone understood this was very dangerous for kids who don't have that ability to stop. It's bad enough for adults, right? So in social media, we have both product liability and public nuisance going forward. So it's not a question of what is the easiest, it's a question of what's the appropriate theory on which to recover for all of the different kinds of injuries that are occurring.
You want to weigh in on that, Zach?
Yeah, sure. I mean, I think Jennifer hit the nail on the head, right? I mean, my firm brings both single plaintiff product liability cases under, the standard, product liability laws for catastrophic injuries related to products, but then we also bring economic loss class actions. Kind of to dovetail a little bit off what Marc said, I mean, yeah, these kinds of things are going to expand, much like data breaches are expanding as the population grows and the kind of thirst for consumer products grows. These are going to go kind of grow larger likewise. And this is just another way to skin the cat in a lot of ways, right? I mean, when you go to purchase a product, and I think the courts and some of the bigger MDLs have recognized this in response to the kind of defense arguments that an economic loss claim should not occur until an injury is manifested. It's why should somebody who has bought something for which they have not received the benefit of the bargain for, why should they wait until the product becomes defective and causes an injury, causes a fire, causes a flood in the home? That's just another side of the coin. In a lot of ways, it can be preventative, right? As Jennifer mentioned, on the effectiveness front, oftentimes in the economic loss and product defect class actions, you're also seeking injunctive relief, whether that's modifications to a recall, whether that's to recall if it's a pre-recall case. That is an avenue for recovery that exists, especially under state laws where the product liability statutes do not allow for similar kinds of recoveries and are focused more on personal injuries. So to Marc's question, I think it's a great one, and I think oftentimes it gets cast as plaintiffs' lawyers pivoting to whatever's easier. It's not plaintiffs' lawyers pivoting to whatever's easier. It's plaintiffs' lawyers pivoting to Jennifer's point to what's most effective.
You know, on that effectiveness point, and this is just a general question that I'd like you to maybe touch on, is it seems that there's a tension between when situations arise that may result in mass tort litigation, that there's a tension between utilization of the regulatory system and responsibility of regulatory agencies versus then using the judicial system to seek what's most effective to redress the situation. And what I guess my question is that with increasing mass tort litigation, is that a symptom of a failed regulatory system or a symptom of a failed ability to use the regulatory system the way that we understand it's supposed to be used?
That's a good question. I definitely think that in these areas where there are perceived social ills, that there's a feeling by some that where the regulators are falling down, where the legislatures are not enacting laws, that somehow courts have a duty to step in and fill the void. And Jennifer may remind me, because I know I'm going to get this wrong, but and I wasn't involved in opioids, but somebody had mentioned, like on the very first meeting with Judge Polster, he mentioned something to the effect of, like, nobody else has solved this problem, and I'm going to do it. It wasn't, is this a tort? You know, is there cause and effect? We got a social problem here, and I'm kind of the sheriff on the job.
Yeah,
you know what I'm
I
saying?
think the thing was
Something
more
like
collective,
that.
like, you know, we all know there's a problem, now we figure out what we're gonna do, you know, to
Right.
fix it. Yeah.
And so some of this maybe is a failure on the part of regulators, or in that case, you know, not looking at doctors that are overprescribing. I mean, there is a solution to it besides looking to torts. But, you know, I think that is the bigger question, Your Honor, is when you have social ills, whose job is it to solve these? Is it the legislators? Is it the regulators? And if they're not doing it, which sometimes itself is a policy choice. So like not doing something on climate change, you may have some in the audience that say, well, if EPA or other authorities are not stopping climate change, then I need to step in and do that. Well, maybe they're not doing it, and that itself is a policy choice. So.
Yeah, I guess I would think about it, I don't think anyone's failed necessarily. I certainly don't think it's a failure of the judiciary to grapple, again, with these issues. This is not something made up out of whole cloth. There's a long history of public nuisance as an additional avenue to seek relief for the appropriate type of harms. But having said that, I mean, I think in opioids, for example, was there a failure with respect to DEA? Again, I'm not going to blame them. DEA was overwhelmed, and that's probably our fault as a policy choice in terms of how much funding we gave them. They were getting just huge volumes of data from the manufacturers and distributors that literally went into a drawer, wasn't looked at, because they couldn't deal with it. And so, you know, so they triaged. You know, they went after the worst first. You know, the folks who were, you know, selling out the back door, you know, selling prescriptions out the back door. But in the meantime, that was huge volumes and years of ongoing, supposedly legitimate manufacture and distribution that was actually fueling the crisis. So I don't blame DEA, but the role that we expected DEA to play in monitoring and controlling and enforcing our Controlled Substances Act didn't happen until way too late in the game. Similarly with FDA on opioids, you know, they were lied to in terms of, you know, the risks and safety. But also, you know, and anyone who's litigated these cases knows there's an ongoing game. The manufacturers are constantly pushing the envelope on how much can we get away with in terms of the warnings and what we say in our labels. So I've actually, you know, I saw the document saying, look, we know that we're likely to get, you know, dinged by this from FDA in about 6 months, but that'll get us over the hurdle till we have that next one, you know, coming out, the next product coming out. So we're going to do it. We're going to put in this very clearly misleading statement that we think is going to get dinged just to buy that time. So is that a failure of the FDA? I don't think so. But I do think, as a policy matter, we do need to support our regulators and empower them to do what we expect them to do. And we sit in the back to make sure that that happens.
Okay. We're at the point in our program now where microphones are open. Don't rush them all at once. And great, we've got folks moving forward already. We'll start here on my left.
From cases that I've seen, there seems to be a growing collaboration between the plaintiffs' bar and state attorneys general. State attorneys generals are hiring out plaintiffs' bar. That works until there's a limited fund. And it seems that there are situations where there's conflict between what's in the interest of the victims and what's in the interest of the states. And I was wondering how the plaintiffs' bar and others, do they see it as a conflict and do they reconcile it? In other words, every dollar that goes to a settlement with the state attorneys general is a dollar less that might be available at times for victims. Do you see it as a conflict?
I mean, I can address it. I mean, I think opioids is a really good example of, I don't think there was a conflict. There was a very intentional effort to try to maximize for all the constituencies. Whereas there's some heated discussions, I'm sure that there were in that. But I don't see it as an inherent conflict. And again, I think there's different types of injuries that are trying to be compensated for. We spoke, though, to the limited fund. And everyone's eyes open, about that when there's a limited amount of money. How do we actually ensure the maximum resources are going to the right places? Do we get it perfect every time? Probably not. But I don't think the answer is to say stop and not have any compensation. I think the answer is to have more sunshine on the process, which is one of the things we tried to do in opioids. In the settlement, there's a public reporting requirement so folks can see what money is being spent on. And I know there's been reports that have been critical of spending of opioid settlement monies in some locales. Good. That was the whole point of having that in the settlement process, is to allow the public to have eyes on what is happening, to participate, to go to their legislators and say, no, I think this is a misallocation of the funds. It should be used over here, not there. And if that doesn't happen, to see them at the ballot box.
Public accountability. Here we go to my right.
Thank you. Good morning. Thank you, Justice Montgomery, counsel. My question has to do with Ms. Scullion's comment about the use of the Behrens doctrine, and that is when a state attorney general asserts Behrens as far as bringing a matter, do you feel that it subsumes all the claims of the local governments? And if it does, who may assert the doctrine? May only the AG, representing sovereign entity, assert Behrens, or is it the basis for a motion to dismiss by the defendants? Thank you very much again.
Absolutely. It's a great question, and it's our favorite answer. It depends. It varies state by state in terms of what the scope of authority is for the Attorney General in a parens patriae action versus local government, how much they are seen as being, or not seen, but are legally independent, have their own independent rights and injuries for compensation.
Yeah, I would agree with that, because I litigated that issue in West Virginia. And it is state by state, and it goes to the authority authorized to the Attorney General under appropriate statutes in the Constitution of the state. Ultimately, I mean, there was a large AG action against opioid distributors back in the mid-2010s. And then the larger opioid cases that Jennifer talked about followed that. And obviously, that was the subject of an immediate motion to dismiss by Distributors Council, who were named in the second wave, and ultimately found out that, no, that the AG's action did not subsume the claims of counties and municipalities.
We'll go back over to the side.
All right, and just to follow up on your comment about the judge looking for a remedy in OxyContin, and what are judges to do when we're looking at maybe stretching a doctrine beyond its traditional use, when there may be obvious other remedies? And so, for instance, when we're talking about a pharmaceutical company that is lying to, misleading regulators and doctors, aren't the obvious remedies the deceptive and unfair trade practices claims, Medicaid fraud claims, Medicare fraud claims? Aren't those good remedies for consumers and institutional purchasers? And why should judges again be kind of receptive to kind of stretching the boundaries of the law when there is an adequate remedy?
Yeah, and I think the question is sort of remedy for who. So you mentioned in the case of opioids, payors, insurers. Can they sue for the injury to them? I think the answer is yes, but that doesn't help. For example, San Francisco. One of the areas of spending they had was in their libraries having to replace the toilets. This is going to sound amazing, right? With toilets that could crunch needles, because the predictable result of prescription opioids epidemic was then people would transition to illicit drugs, including injectable opioids. And what San Francisco was finding was that their library toilets were getting clogged with needles. So they had to install a whole new set of toilets with these crunchers. There's a different word for them. I like cruncher. In there, or similarly, San Francisco had to start having public health officials deployed on the street to be handling the overdoses that were happening, on the street. So I think, for those, I don't think you could necessarily go and bring a fraud action. This was a public health, crisis and a impact on these public health and safety concerns. So I think public nuisance is the available, remedy for that. That being said, I do think, again, I hear time and again that there's concern that the courts are sort of run amok with public nuisance. Just look at the case law. The courts are really working very, very hard. All of you are working very, very hard to figure out when is it appropriate to use public nuisance, when is it appropriate to use, another theory to ensure that the harms are actually redressed. It's not easy. It's evolving. But I think that's one of the wonderful things about our system, is that we do keep grappling with these issues to figure out the answers.
Any other thoughts? Okay. Next question.
I have a question about the social media litigation. New York just recently raised the age of criminal responsibility from 16 to 18. And just recently, the governor passed a law banning cell phones in all schools. So I understand that addresses the litigation for the schools that you had mentioned as a result of the bullying, the depression. I have sat for a number of years as a family court judge, and I'm sure a large number of my colleagues still sit in family court. Are you seeing any litigation, whether on the prosecution side or the defense side or the plaintiff side, either brought on behalf of parents who are saying, I'm seeing this conduct in a family law context, or where there's prosecution criminally against parents as a result of the conduct of their children resulting from social media? I understand that you mentioned it by way of the schools are the ones who are bringing this action, and they have all of their claims. Is there anything by way of the family and what they're able to do or not do?
So it's a great question. I think not. I haven't seen exactly, I think, what you have in mind, but there certainly are a number of families that have brought individual actions, usually with respect to either a minor child that's had health issues as a result of their social media use, or unfortunately, in a number of cases, a child has died as a result of social media use. Those families, are suing. I haven't looked at, so I don't know whether there's been, prosecutions. I don't know. I'm not a family law practitioner, so I don't know the extent to which it's coming up in family cases. I would expect that it is, though. I mean, I would think that in looking at, what is in the best interest of the child in terms of placement, maybe one of the things you're looking at is, how is that parent monitoring or dealing with social media with the child? It wouldn't surprise me if that's coming up, more and more. It's social media and its impacts are ubiquitous,
Or
right?
maybe even a class action on behalf of parents, maybe?
Class actions for injury are almost impossible. Because the courts have found that the damages are too individualized. So that's again, looking at the available theories and procedural mechanisms to deal with these aggregate or collective, harms. Class action can be one sometimes, but sometimes it doesn't work because of the way things have worked out in our case law. So what are the other available options, right? So public nuisance is one of those.
Thank you.
You're very welcome.
Let me go back to the last question for just a second that was asked about if you're struggling with a question about how far a concept like public nuisance should be taken, how do you resolve that when there could be other alternative claims that could be asserted? I think that's a perfect example of what took place in the states that have looked at public nuisance and found that it was not appropriate in a pharmaceutical context. One of the things they said was, it's a legal substance. How could you have public nuisance of the use of a legal substance, a substance that is not unlawful or illegal? I think that a lot of courts are going to, when they struggle with this question of how far public nuisance should be extended, and there's no question it's broader now than it was when the concept evolved initially as largely relating to interests in land. But for those circumstances, I think that should be a warning that if you think you're having to extend it beyond the realm of where the law should go, but there are other ways that you could address the perceived harm or the pled harm, then maybe those are the claims that should survive, as opposed to continuing to extend public nuisance into areas. Because frankly, the real question that we've all struggled with, and courts have struggled with for years, is this whole concept of public right that has been infringed. What are the parameters of that public right?
All right, and we're getting to the close of this particular panel. Are there any final thoughts? Any other comments?
No, I mean, again, I think this is both interesting and challenging and exciting to, again, be trying to grapple with how do we address these broader ills, broader injuries in ways that are lawful, consistent. We're a country of laws, which I'm incredibly proud of, right? So how do we do it in a way that's lawful, in a way it's going to get appropriate compensation to the appropriate parties, and that, frankly, is efficient. And I welcome the opportunity to continue on this challenge with all of you.
I'd say the only thing I was going to say during the remarks, when I was talking about what are super torts, and I went through and identified specific products, is that the challenge that we have, I think going forward, that the courts will have to grapple with, is that the combination of third-party litigation funding and social media means that anytime there's a product injury, you have a super tort. And I think that is one of the things that has changed, that, it's easy to identify 3 or 4 mass litigations of today, but given the nature of, the playbook that's been developed with great success is funding, flood the airwaves with legal services advertising, and you can very quickly generate, 10,000, 30,000, 50,000 cases in a 3 to 6 month period. And so, we have today, maybe different than 10 years ago, the reality that anytime there are injuries for a different product, it's going to become a super tort. And the courts are going to have to grapple with this more and more, where you suddenly get flooded with an avalanche of cases that develop some seemingly out of nowhere, because that's the new playbook, and it's working, and because of these factors that we have, it's not going to go away.
And just briefly, just to respond to Mark's points there.
20 seconds.
I'll be very brief. Third-party funding and social media. I think you could certainly look at it that way. The way I look at it as third-party funding, access to justice, right? Super important. The second point on social media, that's awareness, right? So is it necessarily an ill that these kind of quote-unquote super torts are proliferating? I don't think so. I think it's people becoming aware of their rights and folks having funds to advance them. And just to briefly dovetail, we talked a lot about compensation. The second prong that's important in advancing the tort system here is deterrence, right? Something really to keep in mind in our civil justice system is both compensating people is a critical, probably primary policy point, but deterring is also important.
Well, thank you very much for that last point there, Zach. And I hope we all would welcome and appreciate the input and the substantive conversation we've had in this panel. So let's give them a round of applause.